Right now, somewhere on Earth, someone is making a phone call. 8 billion people live on a planet wired together by a technology that reshaped every boundary, geographic, commercial, personal, that human beings had ever known. Ask anyone who invented it. They'll say Alexander Graham Bell. They're wrong. On the morning of February 14, 1876, Valentine's Day, as if history needed the irony, two filings arrived at the United States Patent Office in Washington. DC-1 was a caveat, a legal notice of intent, submitted on behalf of an inventor named Elisha Gray. The other was a full patent application, filed by an attorney representing Alexander Graham Bell. What happened next, in that building, in those hours, possibly in a back office between a patent examiner and a man with something to gain, is one of the most consequential and most disputed mornings in the history of American technology. Gray walked away with nothing. Bell walked away with patent number 174,465, the most valuable patent ever issued by the United States government. And Elisha Gray, who had spent years developing the exact technology that patent described, spent the rest of his life watching someone else take credit for his life's work. Here is what that morning cost the world. Not just one man's legacy, but the honest record of how one of humanity's most transformative inventions actually came to be. Elisha Gray was born in 1835 in Barnesville, Ohio, a small Quaker settlement in the eastern part of the state. His father died when Gray was 12. The family had no money. He worked farms and carpenter shops to keep himself alive, which meant formal schooling was a luxury he could rarely afford. What he had instead was something that no curriculum can reliably teach: an instinct for how things work, specifically how electricity moves. He managed to attend Oberlin College in his 20s, not as a degree-seeking student at first, but as a laborer who traded manual work for the chance to sit in on lectures. He eventually enrolled properly and studied physics, specifically electrical science, which in the 1860s was a field that felt like the edge of the knowable universe. The telegraph existed. The idea that electricity could carry not just a signal but a human voice, a sound, a breath, a word, was still theoretical. Gray understood early that it didn't have to stay that way. He moved to Cleveland, then to Chicago, and began filing patents. By the early 1870s, he had dozens of them: a self-adjusting telegraph relay, a telegraph repeater, a device he called the harmonic telegraph, a system that could send multiple messages simultaneously over a single wire by transmitting them at different frequencies. This was not a hobby. This was sophisticated, original electrical engineering at the frontier of what was technically possible. Western Union, then the most powerful communications company in America, was watching him closely. Investors were watching him. The scientific community knew his name. In 1872, Gray co-founded the Western Electric Manufacturing Company in Chicago, which would eventually become Western Electric, one of the most important telecommunications companies in American history. He was not a dreamer tinkering in a shed. He was a legitimate, working, commercially successful inventor. He had colleagues. He had capital. He had credibility. And he had a new idea. He was going to build a machine that transmitted the human voice. The origin of Gray's telephone insight is documented in his own papers and is, in its way, a beautiful story. His nephew, a young boy visiting Gray's workshop, was playing with an electrical toy in a bathtub, holding a coil connected to a battery and dragging it against the zinc lining. The vibration produced a sound, a tone, not just a click, not just an on-off telegraph pulse, but a sustained, variable pitch. Gray recognized immediately what he was hearing: electricity, modulated by vibration, producing something analogous to a voice. He went to work. He developed what he called a liquid transmitter, a needle suspended in a conductive fluid, with the resistance varying as the needle moved up and down in response to sound waves. As a person spoke into the device, the vibration of their voice changed the resistance of the circuit, which changed the electrical current, which changed the sound reproduced at the other end. This is, in its essential mechanism, how the telephone works. Gray understood this. He built it. He tested it. He wrote it down. By early 1876, he had documented his design in detailed technical drawings. He brought those drawings to his attorney, William D. Baldwin, and instructed him to file a caveat at the patent office. A caveat under the patent law of the time was a formal declaration of an invention in progress. It was a legal placeholder. It said, "This person is developing this invention. Notify them before issuing a patent to anyone else on the same subject so they can contest it." Baldwin filed that caveat on February 14, 1876. The same morning, a different filing arrived. Alexander Graham Bell's attorney, Marcellus Bailey, delivered a full patent application for a device bell called an instrument for transmitting vocal or other sounds. Bell's application was a patent, not a caveat, a request for the actual grant of exclusive rights, rather than a notice of work in progress. Here is where the story becomes something more than a dispute over priority. Here is where it becomes something darker. Under the law and procedure of the Patent Office at the time, both filings arrived the same morning. The exact order, who was logged in first, whose papers were handled first, whose application received the critical entry timestamp, has been contested for a century and a half. The Patent Office's own records are inconsistent. What is documented, and what has been examined by historians including A. Edward Evenson in his meticulous 2000 study, is a sequence of events that is difficult to explain by coincidence alone. Zenas Fisk Wilbur was the patent examiner assigned to both filings. He later, years later, under oath, made a declaration that has never been fully reconciled. He admitted that he was an alcoholic with debts. He admitted that he had borrowed money from Marcellus Bailey, Bell's attorney. He stated that he had shown Bell's representatives Gray's caveat before Gray's attorney had been formally notified, which was a direct violation of Patent Office procedure. He claimed, in one version of his statement, that he had received payment for doing so. Wilbur subsequently recanted parts of that declaration and reaffirmed others. His account is contradictory. But the underlying charge, that Bell's team had advance access to Gray's confidential filing and used it to modify Bell's application before the patent was issued, has never been definitively disproved. What historians have documented is this: Bell's original patent application, as filed on February 14, did not describe a liquid transmitter. Gray's caveat did. After the filing period, after Wilbur had access to both documents, the version of Bell's application that moved forward included a liquid transmitter. Bell himself, in his laboratory notebooks, made no notation about a liquid transmitter on February 14. His first recorded experiment with a liquid transmitter is dated March 7, 1876, one day after his patent was officially issued. Patent number 174,465 was granted on March 7, 1876. Bell's notebook records his first successful voice transmission test on March 10. The famous line, "Mr. Watson, come here, I want to see you." Read that sequence again. The patent was issued before Bell had successfully used the device the patent described. Gray filed a legal challenge. He argued patent interference, that Bell's application had been fraudulently prepared and fraudulently processed. The case went to the courts, and then something happened that American legal history has produced many times since. Institutional weight crushed a legitimate claim. The courts ruled for Bell. The Patent Office, whose examiner had admitted under oath to procedural violations, was not held accountable. Bell Telephone Company, already building its monopoly, had the resources to fight every legal challenge through every available appeal. Gray did not. The legal costs alone were devastating. After years of litigation, he dropped the interference case. He did not disappear quietly into obscurity. He continued inventing. His later work includes the teleautograph, a device that transmitted handwritten messages electrically, a fax machine, in everything but name. He held over 70 patents in his lifetime. He was respected in the scientific community. He was not poor. But the telephone, the invention that would underpin global communication for the next 150 years, that Bell Telephone would use to build one of the most profitable monopolies in American corporate history, that was gone. Decided. Legally settled. The law had spoken, and the law had been wrong. Gray died in 1901. He was 65 years old. He died in Newburyport, Massachusetts, 25 years after that February morning. He had spent a quarter century watching the Bell Telephone Company expand into something almost incomprehensibly large and valuable, built on a patent that he believed, with documented evidence to support him, had been taken from him through a corrupt proceeding. What survives is not just the injustice. What survives is the evidence, and it is specific. Gray's caveat, filed February 14, 1876, describes a liquid transmitter in precise technical detail. Bell's original patent application, as filed the same morning, does not. Bell's notebooks show no record of liquid transmitter experiments until after the patent was granted. Wilbur's sworn declaration, despite its contradictions, places him at the center of a procedural breach that directly benefited Bell's application. Historians who have examined the original patent office documents, including Seth Shulman in his 2008 book, The Telephone Gambit, have documented what they characterize as alterations in the marginal notes of Bell's application, written in a different hand, describing exactly the liquid transmitter concept that appeared in Gray's caveat. None of this has been adjudicated since the 19th century. The Bell patents have long expired. No court will reopen the case. The historical community has not reached consensus because the documentary record, though deeply suspicious, contains Wilbur's unreliable testimony as its most explicit piece of evidence, and Wilbur is a compromised witness. What we are left with is a preponderance, not certainty, but a weight of specific, corroborating, time-stamped evidence pointing in one direction. History has offered Gray partial rehabilitation. He is recognized in technical histories of telecommunications. Oberlin College, where he once traded carpentry for physics lectures, acknowledges him. The IEEE, the world's largest professional organization for electrical engineers, has documented his claim. The Smithsonian's holdings include his papers. In 2002, a Canadian parliamentary resolution declared that it was Antonio Mucci, an Italian immigrant inventor, who should be recognized as the telephone's true originator. A resolution aimed partly at complicating Bell's canonical status. The story of who invented the telephone has been officially unsettled, if not officially resolved. But there is no Elisha Gray Day. There is no Gray Telephone Company. The company he co-founded, Western Electric, was absorbed into the Bell system, the very monopoly built on the patent he contested. The institution that grew from his entrepreneurial work was consumed by the entity that displaced him. His name does not appear in most school curricula. Ask a room of 100 people who invented the telephone, and perhaps one will say Elisha Gray. Here is what that February morning actually was, not just a story of one man's loss, but a case study in how invention gets assigned in America. It was never simply about who had the idea first. It was about who had the attorney who knew the right examiner, who had the resources to keep litigating, whose name, once attached to the patent, became too economically valuable to dislodge. Bell Telephone was a billion-dollar company within a decade. Its investors had no interest in historical accuracy. The legal system that adjudicated the dispute was not designed to excavate truth. It was designed to produce a final answer. And once it did, the weight of commerce and precedent and corporate interest made that answer permanent. Gray built something real. He documented it. He filed the paperwork. He followed every rule the system required him to follow. The system, on one specific morning in February 1876, failed him, and not passively. There is credible, sworn testimony that it failed him deliberately for money. The telephone is not a metaphor. It is a machine that changed the structure of human civilization, how families stayed connected, how businesses operated, how governments communicated, how wars were fought and ended, how the modern world was built. Every device you carry today that makes a call is a descendant of patent number 174,465. And the man whose documented work described the mechanism at the heart of that patent died without credit, without the recognition the history books reserve for the inventors who, officially, legally, permanently, won. Elisha Gray did not fail. He was failed. There is a difference. And the fact that we still have to make that argument, 150 years later, says something about what we choose to remember and what we allow to be buried. The evidence is there. It has always been there. What it asks of us now is simply the willingness to look.